The Boise, Idaho Transportation Department campus on State Street remains empty, and it likely will for some time because of what happened with the transportation budget to end last legislative session. Passing that budget canceled the sale to a private group. The budget bill went into law without Governor Little's signature because, as he explained, a veto would have stopped nearly $600 million in road and bridge repairs around the state of Idaho. But the inevitable lawsuit was eventually filed by the Hawkins companies, the Pacific companies, and FJ Management, claiming the state reneged on a done deal. Okay, so now that case waits to be heard by the Idaho Supreme Court this summer. But that's not the only legal development in this matter. The other one pits the governor's office against the attorney general's office, and Joe Paris joins us now to kind of, well, explain the whole filing fiasco.
Yes, and to be very clear, we're going to find out a lot more about this in the coming days. But here's a starter pack for you just today. The Idaho Supreme Court filed a notice that oral arguments in this case will be scheduled for August 19th, 23rd, or the 26th. And the request was made to expedite the case, and it's now on track for that. But to answer your question, Brian, Idaho Attorney General Raul Labrador filed a brief in response to the suit filed by that private group. He did so on behalf of the defendants, the state of Idaho, acting by and through its Department of Administration, acting as the statutory agent for the state of Idaho, Transportation Department, and the Idaho State Board of Examiners. Oh, that third group, the State Board of Examiners, is where there seems to now be a new conflict. So what is the Board of Examiners? And I'll just quote from our Constitution. This is for Article 4, if you'd like to follow along at home. The Governor, Secretary of State, and Attorney General shall constitute a Board of Examiners with power to examine all claims against the state. Claims like the ITD suit. And the examiners, again, are the Governor, Secretary of State, and the Attorney General. The Attorney General, Raul Labrador, he and his team submitted paperwork, a response to the suit back on May 15th. It was an in-depth answer and response to the claims made by the private group. The problem, Governor Little says he never saw or signed off on the filing before it was submitted to the court. His office writes to me in a statement, quote, "The governor has learned that a brief and answer were filed on behalf of the Board of Examiners in the lawsuit before the Idaho Supreme Court. The filings were neither presented to nor approved by the board prior to filing." So yeah, that Board of Examiners, they all need to agree. So is this tantamount to a legal representative filing things on behalf of their client without their knowledge? That is the big question right now. And you can simply infer here that Governor Little has a difference in opinion about what arguments should be made in court, what was put in that brief. And to be clear, the private group, they are asking for the Supreme Court to declare part or all of the ITD and Department of Administration budgets unconstitutional because it had language in there blocking the sale. And they want to require the state to go through with the sale. So those budgets each contained language revoking the sale. And there's been questions for weeks about if those budget bills are legal, if they survive Idaho's single subject rule for legislation. It's in the Constitution. Well, what does the AG's office think about all of this? They're pushing back on the governor's narrative, saying that the governor's office knew full well what was going on and had options to prevent this whole thing. We'll take a look at a quote here from the AG's office. They say, quote, "The Idaho Supreme Court gave our office 2 weeks to file the brief on behalf of all state parties named in the Hawkins suit. The governor was aware of this deadline from day one. He was informed of our legal strategy at least 1 week before the brief was due. And as the chair of the Board of Examiners, the governor had ample opportunity to call a special meeting but failed to do so. Similarly, he could have vetoed the legislation that triggered the lawsuit. It's curious that his office is trying to blame the Office of the Attorney General for the governor's failure to act promptly on his desired policy outcomes. There are several ways that this could play out, and we will have to wait. I don't want to sit here and guess because there are a lot of different things that could happen. But Brian, as you can imagine here, there is some intensity on the second floor at the State House. The AG's office and the governor's office appear to be at odds on this topic. This is not the first time they've had a difference of opinion.
So what are the ramifications then?
There's a lot of different things that could happen. Labrador could be asked to not be part of the case. They could have special counsel. They could have a retraction and they could refile it. So there's a lot of things that could happen. We'll keep an eye on it.
All right. Thanks, Joe.